Okay, so the second presentation is on data sharing and infrastructures, but I will focus mostly on data sharing. It is maybe also good to have this second presentation to see that competition related and going beyond competition, there is still more regulation to come or in existence, which shows that overall the European Commission, we can say, is very, or the European Union is very ambitious regarding digital markets regulation. We can also say that there is a clear trend of over-regulation at the moment. So if we move to the first slide with content, we have here a distinction to make. The original focus of data-related regulation was basically protection of fundamental rights, right? And in this context, it was about the use of data to express your personality, for example. And then if someone uses the data that interferes with your personality rights, and that is the GDPR, right? So the first important European regulation on data. However, shortly after the GDPR was passed, the focus shifted because obviously in the online world, data is not only important as an expression of privacy of yourself or identity, but it's also an asset that can be used for economic products, services, transactions. And here, when you interfere with the data, it's not that you need a justification, like, for example, I need to have access to privacy-related data because it's for health treatment purposes. But in the economic context, you, for example, if Facebook uses data, then the question is, do end users get a fair share in the proceeds from that use of data? So you have to make a balance between cost and benefit. Now, if we move on to the next slide, we see that this data-related regulation is just part of a much bigger, collection of new rules. Here on this slide, which I copied from the other presentation, I structured a bit the European rules, also taking into account proposals. On the one hand, in one column, the first column, you see rules that concern platform market structures as such, and it's really the focus on the platform markets and the infrastructures that sit between the various users. So that's the Digital Markets Act, and also some older pieces of legislation. Then we have in the second column rules concerning the protection of commercial platform users. Here we have the P2B regulation, the Directive on Business Secrets, and maybe also for market entry, the geo-blocking regulation and the vertical block exemption regulations. So here the focus is on the bilateral relationship between the platforms and the commercial platform users. Then we have also in the third column rules dealing with the protection of end users vis-à-vis platforms, or in other business relationships in the online world, the directives on unfair terms, the proposed artificial intelligence regulation regarding algorithms. And then we have a new strand of regulation concerning the liability of platforms for content. Here it's the Digital Services Act, the Copyright Directive, which impose liability on platforms, for example, for hate speech, or for counterfeit products, or for pirate copies, and so on. Also the proposed European Media Freedom Act regarding media content may fit into this column. And if we take the last column, it's on informational and communication technological security, Also here we have rules that deal with the online world, the cybersecurity directives, and the regulations on identification services and financial services provided over the internet. So lots of different areas of the law where we see many new developments. Most of these acts were passed after 2014-15 or are in the making. So this is all very new. And then there's the second last column regarding obligations concerning data and data infrastructure. And there we have this distinction between privacy-related regulation and other regulation, right? So on the left-hand sub-column, we have the GDPR and the e-privacy directive. On the right-hand column, well, there you first see the FFDR, so free movement of data regulation, which was passed in 2016, shortly after the GDPR. It was meant to be a complement to allow for sharing of data across borders to the extent that it's non-personal data. However, this regulation then actually triggered further regulations which are directly connected, and it's not possible, different from other EU regulations, I think, to consider these regulations separately. The FFDR and the DGA, Digital Data Governance Act, and now the Data Act are all regulations that deal with various aspects of data, and they are interrelated. It is, although the Data Governance Act mentioned here is about public data infrastructures, you need to take it together with the FFDR and to some extent with the Data Act. So that is different from, for example, the Digital Markets Act, where we can say this is an autonomous set of regulation for gatekeeper platforms. Here, these three should be seen together. Now, the FFDR, however, only includes very few rules, substantive rules, and the DGA, as I said, is about public data infrastructures. So we can leave it out for the purposes of this presentation, which focuses most on access to data and not so much on data sharing, facilitation, or on the cloud infrastructures, which are the other aspects regulated in these regulations, nor on public data. So we focus just on access to data, and this is covered basically by the Data Act proposal. It's a proposed regulation. Now, but before we get to the Data Act as such, what are the general principles that are being used for questions of access to data, data exclusivity, and data sharing? Well, I said before, we have this key distinction between data as some kind of expression of yourself on the one hand, or expression also, for example, of ideas that you have, that is business secret rules on the one hand, and then the data as an asset that can feed into products and services. Now, on principle, all data can be used as economic assets, and there it's not relevant on principle whether it's structured data or non-structured data, big data. For EU regulation considers, at least that's EU regulation, it considers that all data can be used as an economic asset. Data access can then be key to offer and develop complementary services, and if we then think back of the Digital Markets Act, we see that there is also policy interest in granting data access, because we don't want just the ecosystem operators to expand their ecosystem by reusing data and innovating through complementary services, but we want also others to be able to develop complementary services. So we need some kind of regulation that allows for data access and technical interoperability, so that new services are possible. And these two functions, data access on the one hand and technical interoperability on the other hand, are closely intertwined. Sometimes you will interoperability rules, for example, will be insufficient if you don't get access to the data that can then shared among the interoperable services. Now, this is the key ideas basically underlying new European legislation, but then we come to certain problems, and one is that data access is not forced in Europe. It is on principle governed by freedom of contract, and this freedom of contract means that those who have the data can decide themselves with whom they want to share the data. There are only very limited limitations to that. On the one hand, there is the essential facility doctrine under competition law, and on the other hand, when the essential facility doctrine does not apply, it's possible that you reach the same results through regulation. However, even where access is granted under these rules, third-party rights may still frustrate access to data. So if you, for example, have to grant access to data where it's personal data, then there may be, as a data holder, then there may be a separate third person that claims privacy rights in the data. The so-called data owner may be a private person, and if it says, well, I'm not in favor of the sharing of data, then your essential facility claim, for example, will fail. You don't get access to the data. Let's move on to the next two slides, where I looked a bit deeper into the rules for access to data that we have. So first, a group category of rules was the essential facilities doctrine. And here I just summarized the main principles that apply. So first thing is the essential facilities doctrine requires a dominant position. Not necessarily regarding the data, but there must be some kind of dominance. And in that regard, I only want to highlight it. It's quite probable that it's not an issue, but officially the essential facilities doctrine was recognized by the European Court of Justice only for IP-related access rights, not with regard to data. We have the only case law by the European courts we have that goes into the direction of applying the essential facilities doctrine in the here relevant area is the Microsoft case on API. But there is also no reason to assume that the essential facilities doctrine would be excluded on principle for data. So we can assume that the essential facilities doctrine would be recognized by the court also for data, but then we need to meet also additional conditions before access to data can be enforced via the essential facilities doctrine. So in addition to a dominant position, the data as such must be a non-duplicable input for downstream offers on the one hand, and second, without the access downstream, competition must be eliminated. So not just restricted, but it must really be impossible basically to have downstream competition. So the data would be an input product for competition on an output market. So the question is obviously then, is this actually very restrictive? Well, actually we need to consider that EU legislation and regulation under the essential facilities doctrine has developed in a rather flexible way. There has been also regarding IP-related products an easy judgment that said that even a hypothetical market is sufficient if you want to ask yourself, well, is the input actually a product? So if you have data and the dominant company says, well, I'm not interested in selling the data, then this is an argument that will not be regarded as valid or as sufficient if there is at least a hypothetical market, that is, if there is at least demand for the data. If we have someone that says, well, but I need access to the data, then already this claim, well, I don't want to market the data, already collapses, because it's not relevant what the dominant company says, but it's more relevant that there is someone that wants to have access, and that is what is being meant by hypothetical market. The second important modification may come in from the side of national law, because national law may allow to apply the essential facilities doctrine also where you don't have a dominant position, but just some kind of dependence due to a superior bargaining power. That is something that exists in German law. The concept is, as far as I understand, very similar to what we have in Japan, at least the UTP, maybe also the superior bargaining position rules. So, but the important point is that you can then even apply abuse type rules below the level of a dominant position. And that broadens the scope of application of the essential facilities doctrine significantly. So if we move on to the next slide, then we come to the rules for access to data under regulation. Now, regulation may require access even beyond the essential facilities doctrine, so that you don't need to meet the conditions under that doctrine to get access. And we have now certain rules in place, or also new proposals for rules. The broadest of them all is the Data Act, which is only a proposal for now, but which basically can apply to all commercially active data holders. But I will come to limitations shortly. Then we have the Digital Markets Act, which forces large platform intermediaries, the so-called gatekeepers, to grant access to data. Under Article 6, we had this rule this morning. And then we have also rules for public data holders under the Data Governance Act. So if we move on to the Data Act specifically, then we come to the finding basically from a policy perspective that data is being underutilized at the moment. The saying is basically, well, the essential facilities doctrine and the existing regulation is still too narrow, so we need to increase the share of the database economy in the overall economy in Europe, and that is basically a policy decision that led to the Data Act. Whether it's justified or not is another question, obviously. So there is a strong argument then being made in favor of data sharing, but we need to take into account that the essential facilities doctrine in particular is narrow for a reason, and that is, if you force companies to share their data, they may say, well, then we won't invest anymore in collection and generation of data, right? Because if we invest there and then the data has to be shared, then this frustrates our investment. Everyone benefits from the data, and not just us who made the investment, but no one pays us for it. So this is a challenge that has to be overcome if we say that the data is underutilized. So Yeah, and then we also need to take into account basically that some protections may continue to exist. The GDPR, for example, if you start limiting claims under the GDPR, then maybe also consumers will say, well, I won't trust these companies anymore because I want them to respect my privacy, but I don't know what happens to my data. They may be forced to share the data with someone else, right? So these were the challenges that the Data Act had to overcome. And it's found quite an interesting solution, I think. And there we come, however, also to an important limitation. The Data Act proposes data access for everyone in all kinds of business relationships, but only restricted to smart devices. So not, for example, it's not the Googles or Facebooks of this world that have to share their data, that's only Digital Markets Act, but it is like Mercedes-Benz or Bayer Leverkusen, or you name it, so industrial companies. And why does the Data Act restrict access to smart devices? Well, I think the Data Act as such does not really say clearly, but my personal understanding was that the Data Act wants to be in line and consistent with existing regulation and existing legal principles and concepts to the largest extent possible. However, it wants also to make use of economic principles, basically, or economic findings. And one finding is that if you have smart devices, there are two markets involved. You have, on the one hand, an interest of the smart device manufacturer in selling its devices. On the other hand, you may have a separate market or separate demand, at least, for data being collected via the smart devices. But you know that the smart device manufacturer will probably not say, okay, I lose all my incentives to develop smart devices only because I have to share the data, right? So the company will still think, okay, having the smart device is so valuable, I will continue to invest in my smart device even though I know I will have to share the data. And I think the Data Act makes use of this idea, basically, and therefore limits the data access obligations specifically to smart devices. However, otherwise, the Data Act still respects existing third-party rights, at least when it comes to consumer rights. So here the idea is that access must be shared, but in a privacy-compliant manner. However, here also there is some thinking behind it. There may be an interest even of consumers in facilitate sharing of data. Think of, for example, that a car manufacturer builds cars as smart devices. So the cars collect data on the consumer's driving behavior. Now, in this scenario, it's maybe even the consumers that may have an interest in getting the data shared, because the consumer may find out that their car, for example, breaks down in certain situations, so they bring the car to a repair shop, and then the consumer wants the repair shop to analyze the data collected by the car to improve basically the functioning of the car. And in this scenario, this data access would make sense for everyone, so no third-party rights would intervene. The user would not say, no, I am against everything, but rather to the contrary, the user will itself initiate the whole data sharing. And this is basically the solution that the Data Act then has in mind, that it's the user that indeed initiates the sharing. However, there are other third-party rights that can still be obstacle, and that is trade secrets. For example, the car manufacturer may say, in the scenario that I just described, well, we want only our licensed repair shops to receive access to the data, but not third-party repair shops. In this context, however, interestingly, the Data Act is very restrictive and says, well, we limit the reliance on trade secrets so that these cannot be used to put obstacles to the sharing of data. That is certainly a new feature, going also beyond the essential facilities doctrine. Now, if we move to the next slide, then we see that the Data Act goes beyond the sheer facilitation of access to data. In fact, there are also practical difficulties for data sharing that have nothing to do with essential facilities claims. But up to now, I just focus basically on this challenge of that is traditionally tackled by the essential facilities doctrine, that we want to protect freedom of contract and only limit freedom of contract under very limited circumstances, where it is about protecting competition for downstream services. Now, in addition to these issues, we have obviously also other difficulties. For example, that there is an information asymmetry very often between the parties involved in these transactions and other levers that can be used basically to exploit one of the parties involved. The Data Act therefore includes further rules. Smart device manufacturers must therefore take data access into account already when designing the devices. They cannot stifle basically data access claims by saying, oh sorry, my car is not, or my device is not designed in a way that allows for any data sharing. Instead, they must develop standards and other features that facilitate data sharing. And then data that are being shared, and that is not just smart device data actually, but it can also be other data, must be shared under FRIEND standard terms. And also the consumers must be granted portability, so the consumers must be enabled to ask for data sharing. So please note that I need this has to be corrected. The second bullet, there it's not just for smart device manufacturers; it's for any data holders. Yeah, that is an important modification I have to make. Sorry for that. So we move on and now come to the data intermediaries, which is the last part of the Data Act which I wanted to cover. So far we have discussed access to data, data sharing. That is the first chapters, the first 3 chapters basically of the Data Act. Then we have 2 or 3 more chapters in the Data Act, which must be seen in conjunction with other statutes. And that is, above all, the rules for gatekeepers in the Digital Markets Act. The data sharing obligations under the DMA provide for, as I said before, asymmetrical regulation if we take the DMA together with other regulations. And these other regulations, that's particularly the Data Act. The DMA applies to all gatekeepers, but it imposes on all gatekeepers uniform data obligations to grant data access under Article 6. Now the Data Act comes then as a complement to these data access obligations, and says, well, gatekeepers themselves are limited when they want to get access to any data. So the Data Act prohibits gatekeepers from getting all the access that any other companies can get under the Data Act. That's an important feature, important complement, which means that in the end, gatekeepers are subject to asymmetrical regulation vis-à-vis any other market participants. So that's one important point to make. The other important point is that the Data Act also addresses an issue not addressed by the Digital Markets Act, that is cloud services. I said before that digital ecosystems were developed using data, and one of these developments included that digital ecosystem operators said, well, actually, we need to build up our own data storage facilities to be able to basically run our ecosystem. However, we have periods where more data has to be stored than in other periods. Think of Amazon, for example. Amazon's business reaches peaks when there are Black Mondays or Christmas coming and so on. So everyone wants to buy stuff via Amazon at the same time. But then when you are sometime in summer or so, when nobody is interested in sitting at home and looking for goods to be purchased, much of the data storage capacity of Amazon is underutilized. Therefore, Amazon said, well, actually, why not just rent out our data storage space? And that is basically how the cloud services started to develop. And so it's also no wonder that it's particularly Amazon, Microsoft, Google, and so on that offer these cloud services. Now, the Data Act here comes in because it says, okay, in addition to everything that the DMA regulates for gatekeepers, we need to have also specific regulation for cloud services. And here the Data Act seemingly, that is my interpretation of it, considers cloud services to be also some kind of essential facility, or at least some kind of regulation where it may be justified to facilitate access or switching between service providers. However, this is why it's important to note that the Data Act is currently just a proposal. This feature of the Data Act is hugely controversial. The Data Act provides for so-called functional equivalence in getting access to cloud services. Functional equivalence means that when you want to change your cloud service, the original cloud service operator has to make sure that you can use the new cloud service the same way that you could use the original cloud service. Now, these types of obligations, it's debated whether this is actually needed, because when you talk to cloud service providers, they say, well, actually, basic cloud services can be changed or switched very easily. It becomes difficult if you want to get sophisticated add-on services that enrich basically the use of the cloud service. However, there it's very context specific. So if you just force that if you switch between clouds, the new service provider should be able to offer the same experience, then basically either you just disregard that people are specifically for a certain cloud service with its specific add-on functions. So that means you would, by regulation, force the development of standardization, which no one in the market wants to have. Or, which is even worse, you are able to force the cloud service providers to align their standards and so on, which would be a kind of cartel forced by regulation, right? So even though maybe in the end everyone gets nice cloud services that mirror the demand by any cloud service provider they may choose, it is then still based on a cartel that comes along with huge cost. So this is being debated, and we'll have to see whether this functional equivalent standard will survive during the legislative process. Last point to make is public data holders. Public data infrastructures are also covered by the Data Act. Here the situation is still different from what we had before, because here the idea is, well, for example, limited doctrines like the essential facilities doctrine cannot play a role. In contrast, you need to get full access to publicly held data, because publicly held data are publicly funded. In the end, it's the taxpayer that, for example, funds the health system where many data are being collected. So there, the state has to just grant access to the data. It cannot just say, well, I want to make profit by restricting access to the data. That's being the gist, the core idea of the Digital Governance Act. And then the Data Act complements these rules by saying, well, actually, the state itself may also have an interest in getting data, and also there, since it is in the public interest, the state should be granted far access to any data it needs. This is limited to, for example, data that is necessary to deal with natural disasters and things like that. But it is out of this a similar idea that these new rules were now included in the Data Act. With this, we cover basically in an overview everything we need to know for the role of data intermediaries. And I come to the end of my presentation, and thank you very much for your attention.